Thank you, and please be seated. And good morning, everyone. My name is Curry Mingledorf. I'm assigned to preside over this morning's proceedings. We're here for a limited purpose this morning. I do want to note for everyone's benefit that there is, as everyone certainly is aware, considerable interest in what has occurred in our community in the last several days. For that reason, the court has seen fit under Rule 22 of the Uniform Superior Court rules to allow media outlets to record some of these proceedings. However, under those rules, the court has set in place certain limitations, and I just want everyone to know that the media has been informed of that, and I'm confident that they will comply with that. But otherwise, there is to be no filming or recording by any members of the public or any other individual other than those authorized specifically by the court in its signed ruling. Are we ready, counsel, to begin and bring the defendant in?
State's ready, Your Honor.
All right.
Defense is ready.
All right. All right, good morning, sir. Are you Mr. Colt Gray?
Yes, sir.
My name's Curry Mingledorf. I'm assigned to preside over this morning's proceedings. Mr. Gray, I do need to inquire as to whether you're able to read and write the English language.
Yes, sir.
All right. I also want to inform you, I want to ask you, do you understand that you have the right to be represented by an attorney in these proceedings?
Yes, sir.
And you are, in fact, represented today, is that correct?
Yes, sir.
And Mr. Zane Harmon, you're here on behalf of this defendant, is that right?
Yes, Your Honor.
All right, and you understand that you have the right to be continuously represented throughout this proceeding, and if you cannot afford to hire counsel, then this court is obligated under the Constitution to provide counsel for you without cost to you. All right, I am going to inform you of a few other matters, and I'm not going to ask you anything, just inform you. So one is, I want to make sure that you are aware that you have the right to remain silent. You don't have to say anything at all. And it's important to understand that because anything you might say could be used against you at further proceedings associated with your case. I want to inform you of the charges that you currently face. In essence, you are charged with 4 counts of felony murder, as outlined in the state warrants that have been issued against you. I want to make you aware that the maximum penalty for felony murder, so for each count, the maximum penalty is that you could be punishable by death, by imprisonment for life, without parole, or by imprisonment for life, with the possibility of parole. If you have any questions about these charges, then I would urge you to discuss those with your attorney. I would invite you, Mr. Harmon, to inform the court as to whether there's a request for bond at this time. At this time, Your Honor, there is not a request for bond. We will file the appropriate motions if that becomes necessary. All right. An indictment by the grand jury for most felony offenses or accusations, well, you have the right to receive an indictment for these offenses. And I assume Mr. Brad Smith is here on behalf of the DA's office, or he is our district attorney, and he's accompanied by Ms. Patricia Brooks, who is his chief assistant. A preliminary hearing, you'll have the right also to a preliminary hearing, unless you make a bond, which of course at this point there's no bond being requested, or unless you waive such a hearing. You have the right to a speedy and public trial by a judge or jury. You have the right to confront and cross-examine all witnesses. You have the right to call witnesses on your own behalf and testify in your own defense if you so choose. As you sit here in this courtroom today, under the law, you are presumed innocent. Your refusal to testify at any point in any proceeding will not be used against you in determining whether you are guilty or not guilty. Counsel, let me just inquire as to whether there are any other items that the court should address before we conclude this preliminary hearing.
No, Your Honor.
Well, I do have one piece of information to convey to the court. There was a development yesterday afternoon that makes it necessary for our office to have alternate counsel appointed, and arrangements have already been made in that regard. I've already explained that to Mr. Gray, and alternate counsel will be appointed by the end of the day today.
All right, thank you very much, Ms. Donna C. Graves. All right, then with that, this hearing is concluded, and you may escort this defendant out. Good morning, sir. Are you Mr. Colin Gray? Am I pronouncing your first name correctly? Mr. Gray, my name is Curry Mingledorf. I'm assigned to preside over this morning's proceeding. This is your first appearance hearing. And at this hearing, I'm first going to ask you just a few questions, and then I'm going to advise you of your rights and also let you know about a preliminary hearing that's been scheduled for you. Why don't you just state your name, please?
Colin Gray.
All right, pull the microphone down, please. There you go. All right, and how old are you, Mr. Gray?
54.
And are you able to read and write and understand the English language without
Yes,
any
sir.
difficulty?
Yes, sir.
How far did you go in school?
11th grade GED.
Okay. And I note that you have counsel seated with you at the table. Do you understand that you have the right to be represented by an attorney at all times for this and all future proceedings in your case?
Yes, sir.
And do you understand that, of course, if you cannot afford an attorney, that the public defender will be appointed to represent you upon your request?
Yes, sir.
All right. And counsel, would you identify yourself, please, for the record?
Donna C. Graves, we are going to have new counsel assigned to Mr. Gray later today.
All right. Thank you. All right. Okay. Sorry. Just need to make sure that the system is working. And all right. So the following aren't questions that I'm going to ask. I'm just informing you of some things. You have the right to remain silent. Anything you say can be used against you at further hearings or at a trial on the charges that you're facing. For this hearing, you're not going to be questioned about facts and circumstances surrounding your charges. You are currently charged with, and you'll be provided with copies of the warrants if you don't already have them. You're currently charged with 2 counts of felony murder in the second degree. You're charged with 4 counts of involuntary. You're charged with felony cruelty to children in the second degree. Now, for these offenses, for the felony murder counts in the second degree, felony murder in the second degree, the maximum penalty for each count is up to 30 years imprisonment. For felony involuntary manslaughter, of course, again, there are 4 counts. The maximum penalty for each of those offenses is 10 years imprisonment. For the 8 felony cruelty to children counts, the maximum penalty under the law for each of those 8 counts is 10 years imprisonment, for a maximum total possible penalty for the charges that you currently are facing of 180 years imprisonment. If you have questions about these charges, which I assume that you will, the court urges you to discuss those with your attorney. Let me inquire as to whether there's a motion for bond if Mr. Gray is moving for bond at this time.
No, sir, not at this time. We will allow alternate counsel to make that decision.
All right, thank you. I also need to inform you that you have the right to an indictment by a grand jury, and you also have the right to a preliminary hearing unless you make bond or waive such a hearing. You have the right to a speedy and public trial by a judge or jury. You have the right to confront and cross-examine all witnesses. You have the right to call witnesses on your own behalf and testify in your own defense if you so choose. I want to make it clear to you, Mr. Gray, that you are presumed innocent. Your refusal to testify at any point cannot be used against you in determining whether you are guilty or not guilty. I mentioned the first appearance hearing a moment ago. That is being set for you for December 4th, 2024 at 8:30 a.m. Currently that's set to take place in the Magistrate Court of Barrow County. It could be subject to change, but I just want you to know that that is the date that we currently have. In fact, counsel, could you approach, please? I have this, let's see, I need to scratch this out.
Okay, and the signal is freezing up a little bit there. Something totally out of our control, but we're going to continue watching it. So we've got Colin Gray, 54 years old, the father of the Georgia school shooting suspect, Colt Gray, said by authorities to have known the dangers with his son and yet still provided him with a semi-automatic rifle that they say was used to carry out that massacre in which 4 people were killed, 9 others injured. Here are the 4 deceased victims, 2 students and 2 school teachers. Now, this hearing is what's called an arraignment. This is the first arraignment that any criminal defendant will have after their arrest. So this is a quick appearance where you hear they're advised of their rights. The judge asks them if they can read, write, understand the English language, understand the charges against them. The judge informs them of the charges, what they are, and then asks their position on bond. And in both of these cases, neither one of them has requested a bond. I would say that's a very smart move. We're going to get back into the courtroom in just a moment. Stay with us. We continue our breaking news coverage this morning. I'm your host, Julie Grant. Thank you for watching Court TV Live. We're witnessing history this morning. Let's let this sink in because we have another parent being accused of criminal liability in the actions of their child in a school massacre. We saw this first in Michigan, and we watched 2 trials playing out for James and Jennifer Crumbly because of the actions of their son, Ethan Crumbly, and the murders he carried out at Oxford High School. Now, today, we're seeing even more history as that landmark case in Michigan has now paved the legal road to have more cases like it. And now, sadly, here we are with an eerily similar prosecution of a parent providing their dangerous child with a firearm, even when they are said to have known the dangers. That is the allegation for Colin Gray, who is the father of Colt Gray, the Apalachee High School shooting suspect. The kid just transferred to the school 2 weeks before this incident, where he is said to have murdered 4 people and seriously wounded 9 others. Thank goodness those 9 others are going to make a full recovery per the local sheriff. And this morning, these 2 are both being arraigned in criminal court. Colt was arraigned at 8:30. He's being tried as an adult per Georgia law. And now it's Dad's turn. We had a little bit of an interference with the signal moments ago. It's repaired. Let's return to the courtroom now.
This document discusses bond and gives the date of the preliminary hearing, and I guess I could sign that, and then he could just get a copy of it. And then the warrants are attached to that. Sign that, so, and I would like for him to sign it. Turn it around, please.
Sign right there, just saying you're getting a copy of this. He is giving you a copy. He's going to give you a copy of all the warrants, too. Do you want me to send his copy? And the page contains. Just get it on that on the first one. And are these his copies of the warrants?
Those are provided, and they say service copies on them, so I assume that they're for him.
Okay.
Sergeant Briscoe, do you concur with that? Is that what those copies are for?
That's from the detention center.
Those are for the detention center? So he's got his own copies, or he'll have them provided? All right, so the detention center wants to hold on to those. All right, let me, and thank you, Ms. Seagraves. I want to certainly acknowledge the presence of our district attorney, Mr. Brad Smith, and he's assisted by his chief assistant, Patricia Brooks. Is there anything else, counsel, that the court needs to address that I have neglected to address?
No, Your Honor.
No, sir, not at this time.
All right. I do want to thank those who are in the gallery who have an interest and who have appeared. I appreciate the decorum that has been maintained throughout this proceeding, or both of these proceedings today. And with that, this matter is adjourned.
The attorney who's going to represent you, I think his name is James Rogers. We're going to have the official later today. But he'll come and see you probably the first part of next week.